natirang medium period. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
You have to be guided by Section 1 of Rule 138 because Rule 138 is one of the sources of legal ethics. Who may practice law? Ang sinasabi dyan ay any person heretofore duly admitted as a member of the bar or hereafter admitted as such in accordance with the provisions of this rule and who is in good and regular standing is entitled to practice law. Iyan po iyon. That is ULEP versus Legal Aid Clinic. ULEP versus Legal Aid Clinic. Okay? Yan yung doktrina. Alin yun, sir? Yung any person. Kasi any person may mean na pwede palang mag-practice. Kung hindi yan natin makokorek, pwede palang mag-practice ang juridical person. So let us disabuse.
The shares of XYZ, the 40% shares of XYZ, likewise owned by the same foreign corporation owned by foreigners that directly owns 40% of ABC Corporation. So to repeat, let's say the foreigners, right? The foreign held corporation owns 40,000 of 100,000. At the same time, the foreign held corporation owns 40% of XYZ share in ABC Corporation. So the question now is, based on these figures, is ABC a Philippine national? Is it qualified to invest in public utility? Is it compliant with the Constitution?
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply, under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk
in relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay, but in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together we can.
Walang natira video. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
To our dear attendees from different parts of the country, I pray that you're all in great state of health. This free webinar is streaming live via the Villalis Law Center's YouTube channel and Facebook page. If you can hear my voice clearly, please type in the comment section #VLC. Thank you. Yes, thank you. Optimize this learning opportunity. Share this free online lecture to your friends and together learn at the comfort of your homes. I want to formally welcome you all to this free webinar. This is part of a series of free online lectures brought to you by the Virtual Law Companion of Villasis Law Center. Allow me to share to you this good news. The Virtual Law Companion is the newest innovation of Villasis Law Center, which aims to provide an easy, convenient, and quality bar review experience. The Virtual Law Companion is a web application that is hosted on a dedicated cloud server. It can be accessed via the internet 24/7 for any web browser using any device or handheld computers like Android or iOS phones. Meaning, you can study anytime, anywhere, and from any mobile device. Please visit our website at www.villasislawcenter.com to know more about our programs and activities. Before we formally start, please take note of some reminders. First, this free webinar is pre-recorded to ensure the uninterrupted streaming of lectures. Secondly, VLC team will be with you to assist you should you need more information about our program. Please visit and subscribe to our YouTube channel and Facebook page. Without further ado, please give your virtual claps and welcome our lecturer today. Again, this free webinar is brought to you by our Virtual Law Companion. Maraming salamat po. Together, we can make things happen. Together, we can.
Good day, everyone. I'm Yusek Irene de Torres Alogo, and welcome to this free online lecture brought to you by the Virtual Law Companion of Villasis Law Center. Prepare for the bar examinations at any time, anywhere, and from any mobile device. Check out the VLC website at www.villasislawcenter.com for more details and particulars. Optimize this learning opportunity. Like, follow, and subscribe to VLC Facebook page and VLC YouTube channel. Please also share this live stream with your friends and together learn at the comfort of your own homes. And before we start, please comment VLC if you can hear me clearly. All right, so let's start. For today, I will be giving you an introduction to OADR and ADR laws in the Philippines. And for that, we'll be having the ADR policies and related laws and ADR mechanisms and bar exam question that was asked in the previous bar examination. The OADR is an attached agency of the Department of Justice, along with the PCGG, the Bureau of Immigration, the Parole and Pardon Administration, the Bureau of Corrections, the PAO, the OGCC, the NBI, LRA, and OSG. We are the 10th attached agency of the DOJ since 2022. And we are mandated to promote, develop, and expand the use of ADR in both the public and private sectors. And we monitor and study and also evaluate the public and private sector use of ADR. And we recommend to Congress needful statutory changes Like recently, we are working on the proposals for the bill on the ADR Code of the Philippines, and we hope that we can submit this to the Congress by the end of the year. And we formulate standards for the training of ADR practitioners. We also certify that such ADR practitioners and providers have undergone the professional training provided by our office or any other accredited provider. And of course, we coordinate the development, implementation, and monitoring and evaluation of government ADR programs. We can charge fees, like now we are starting to charge fees for 2023. And we can also act as appointing authority of mediators and arbitrators. So please take note if you have cases requiring the appointment of arbitrators and mediators, you can always indicate in your ADR clause that OADR will be your appointing authority. We conduct seminars and trainings, and we also have this ADR library and resource center, and we accept donations and grants from institutions. And we also certify those who have completed professional trainings on ADR. Of course, we help the government in promoting ADR throughout the entire executive department, and we also coordinate with the other branches of the government, like the judiciary and the legislature, in our pursuit to have these coordinated efforts for ADR in the Philippines. Our mission is to promote and institutionalize effective and ethical use and practice of ADR in our country. And the vision is an enlightened society that rises above conflicts and empowers parties in making arrangements to settle their own disputes that is fair and just for all. So these are the things that we do. The most important one that you should remember is the accreditation and certification, because this is also the chance of the government through the OADR to invite all of you to become accredited OADR accredited practitioners for different fields. We have right now, we have negotiation, we have mediation, we have arbitration, and other fields that I will be discussing later on. And these are the courses being offered by the government for lawyers and non-lawyers. Of course, we have the fundamental course on alternative dispute resolution. We have the comprehensive course on mediation. That will be a 40-hour course. And the comprehensive course on commercial arbitration is also a 40-hour course. And the comprehensive course on negotiation is a 24-hour course. And we also conduct 24-hour courses for ADR mechanisms under the Katarungang Pambarangay Law. And as you can see, these are very comprehensive courses because this all leads to accreditation. Okay, if you're curious about the fees of OADR, well, these are the fees. They are very minimal fees, government rates that is very affordable for everyone if you want to avail and become accredited ADR practitioners. And I've been inviting my co-professors from the VLC Law Center to be accredited also. If you want to check out the requirements, you can always look at Department Circular number 49. You will find there the requirements for application and the other nuances that you need to know in order to become accredited. The accreditation is good for 2 years, and it will be a good source of income for lawyers and non-lawyers alike, since other agencies can also avail of your services. And of course, you can do ad hoc arbitration and mediation for parties. Okay, so, and these are the fees if you want to be accredited. If it's a private organization, you can see here the fees that are required to be paid. And if you're an individual ADR practitioner, of course, it will be a minimal fee. And if it's a public ADR program by government agencies, there would also be a very minimal fee. The Philippine ADR was actually born officially by virtue of RA number 9285. And this is the Alternative Dispute Resolution Act of 2004. Here, you will find the policy of the state to promote party autonomy or freedom of the parties to make their own arrangements to resolve their own disputes, and encourage and actively promote the use of ADR, as I have said, both in the public and private sectors. And of course, this is in view of the fact that we offer access to justice through speedy and impartial justice, and that is through ADR. And the primary aim is to declog our court dockets. So a lot of agencies already have been using ADR in their dealings with their both their internal and external stakeholders. And you will find that there are laws already requiring ADR for certain agencies, and that would be covered under legislated ADR arbitration in other modes. But what actually is ADR? So let me lead you to the definition of ADR under RA 9285. It says here that it's any process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency, in which would usually require a neutral third party who assists the parties in the resolution of the issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini trial, or any combination thereof. So if the dispute is being resolved by the judge or by a government agency in its quasi-judicial powers, in the exercise of its quasi-judicial powers, then that is not ADR. Because as I have said, it's other than by adjudication of a presiding judge of a court or an officer of a government agency. And you can see here some of the ADR mechanisms. These are not exclusive enumerations, and the parties can always identify and determine the best suited ADR mechanism for their dispute. These are the key features of ADR. Of course, foremost is confidentiality, because ADR gives a free space, a safe space for the parties to really talk about the dispute, make offers, accept these offers, and in the course of the ADR proceedings, sometimes parties would make admissions and some demeanors, and so it's very important to keep the confidentiality of ADR proceedings, because of course, if it's not confidential, then the parties would not be encouraged to participate in any of these ADR mechanisms. And also, we have fairness of the process. Yes, parties are given equal opportunity to express their positions on the dispute, and for the parties to be able to later on arrive on a settlement of their dispute. And of course, they are given the equal opportunity to generate options to serve as possible solutions to their dispute. And of course, the outcome is expected to be fair and just for all the parties, because as I've said, especially with mediation, for example, the parties cannot be forced to enter into a settlement, and so they are the ones who will really determine what are the obligations that they can actually perform to settle the dispute. And of course, it leads to procedural justice, and it gives accessibility to everyone for justice, so that the parties can achieve what they always wanted based on their interests without necessarily incurring costs for litigation. And it's neutral in the sense that, of course, we have neutral third parties to assist them, and of course, everything fairness, the virtue of fairness and equality is always observed in ADR proceedings. Yes, it's self-determined by the parties according to their interests and concerns, and it adheres to timeliness because it's the parties who actually determine when they want to have everything settled, like after 2 or 3 meetings. It depends on the agreement of the parties, or if it's arbitration, of course, arbitration is a more speedy way of getting an award in a dispute. Of course, as compared to what we have in litigation before the courts. And of course, there are limitations to the scope of RA 9285. And let me just clarify that for the first one, for labor disputes, okay, the RA 9285 did not include labor disputes anymore, although we are all aware of the fact that before the NLRC, the Department of Labor, we have this single entry approach, we have this mandatory mediation, we have this conciliation. Of course, we have that in labor disputes, but the framers of RA 9285 did not include that anymore because in their view, these are already covered by the Labor Code of the Philippines. And for labor disputes, there's already a structured way of doing things, of doing ADR as far as labor disputes are concerned. And so RA number 9285 did not cover it anymore, but it doesn't mean that you cannot do mediation or conciliation, even arbitration in labor disputes, because we have that under the Labor Code of the Philippines. Of course, it does not apply to the civil status of persons, the validity of marriage, ground of legal separation, and jurisdiction of the courts. Of course, jurisdiction of the courts is governed by law, cannot be compromised by the parties, cannot be upon agreement of the parties of which court would have jurisdiction over certain cases. And for civil status of persons, validity of marriage, ground of legal separation, these are all provided in the law. And of course, civil status of persons would require declaration of the courts and of course validity of the marriage. So it cannot also be compromised, right? And future legitim, of course, because this cannot be waived, and it cannot be waived by mere compromise or agreement by the parties. Criminal liability cannot also be waived, but I would just like to clarify that, for example, in mediation, the parties can settle the civil aspect of the dispute. And sometimes when for example, the prosecutor does not have any other witnesses, by virtue of the affidavit of desistance of the private complainant, sometimes the prosecutor would ask the court, would actually ask for the withdrawal of the information because the prosecutor has no witnesses anymore in order to proceed with prosecuting the case. So that's the only time when criminal liability is also extinguished by virtue of the extinguishment of the civil liability in the case. And of course, disputes which by law cannot be compromised, like, for example, the violation against women and children, PAUC law, cannot be compromised. And of course, those that would be referred to court annex mediation. Let's now discuss Executive Order number 523. Okay. So it says here that and under this EO 523, the Office of the President shall manage the development of ADR practice in the executive agencies, and of course, promote the use of ADR to achieve just and efficient administration or administrative dispute resolution. And it also requires periodic review of ADR processes, institutionalization of ADR processes within executive agencies. And of course, the primary goal is to promote party autonomy. And of course, these agencies should also train fact finders, hearing officers, and decision makers, and establish appropriate ADR mechanisms. And then we have Executive Order number 97. And under this law, the functions that I have mentioned under EO 523 have been transferred from the Office of the President to the Office for Alternative Dispute Resolution. And so the OADR conducts these trainings and requires government agencies under the Executive Department to have their ADR programs institutionalized. And we also write letters to executive agencies for them to update the OADR on their ADR mechanisms and the improvements thereon, and that would be every 6 months. Okay, so, and that would also include the Department of Labor and Employment, even though, as I have said, RA 9285 does not cover labor disputes. But as far as EO 97 is concerned, the Department of Labor and Employment is an agency under the executive branch, and so DOLE is also one of those agencies reporting to the OADR regarding their ADR mechanisms. Okay, so under this EO 97, OADR monitors and evaluates the status of ADR programs of all executive agencies. And so we require reports. And there should be a designated senior official and an alternative responsible for developing, coordinating, and managing ADR programs and related activities. And of course, there must be compliance with Section 4 of EO number 523, including the particulars of any such ADR program. Let's go now to ADR policies and related laws. Just bear with me here because this is quite long, but let me now introduce you to the Philippine ADR. Of course, this started in pre-colonial times when our elders, elders in indigenous cultural communities would resolve disputes with the help of their datus and other seniors and elders in the community. And until now, this is being done in some areas in the Philippines where we have indigenous cultural communities. And for this purpose, for example, if there's also, of course, we have the barangays already. So when there is failure in resolving disputes before their datus and elders, of course, they would have to refer their constituents still to the barangay for the issuance of certificate to file action in case there would be no settlement between the parties. And of course, we have in 1949, the Civil Code of the Philippines. Okay, wherein for the first time, there had been provisions about compromises and arbitrations. And that's in Articles 1159, 2028 to 2046. Okay, so for the first time, the members of the judiciary, lawyers were informed that, yes, it is possible to have compromises and to submit cases to arbitration. However, because this is a substantive law, and of course, everyone's waiting for a procedural law to follow on how to implement these compromises, arbitrations in certain disputes. And so it has not become really that popular during that time. In 1953, we had RA 876. It's the Domestic Arbitration Law of the Philippines. The Philippines is among the countries with the earliest enactment of an arbitration law, a domestic arbitration law. However, as I have said, this again is a substantive law that actually required a procedural law for everyone to know how to implement this. And so because of that absence of procedural law, so the judges had different interpretations on how to really implement this arbitration concepts in the cases that they are encountering. In 1967, we had the Philippines acceded to and ratified the 1958 New York Convention on the Recognition and Enforcement of Arbitral Awards. And currently, there are 167 countries or signatories to these New York Convention on Recognition and Enforcement of Arbitral Awards. We call it the perfect convention because even at this time, there are no proposed amendments for this convention. It only tells us that, just to simplify it tells us that even if you have you get an award from a country that is a signatory to this New York Convention, that award rendered by that country is enforceable in the other countries that are also signatories to the New York Convention. So if there are assets in another country that are of the losing party and you want to enforce it in that country, just have to follow the rules and procedure of the courts in that country in order to have this award recognized and enforced in that particular state. Okay. In 1973, we had PD number 242, or the Settlement and Adjudication of Disputes Among Government Agencies. Of course, for government agencies, we discourage them to file disputes against one another because ultimately it's just one government that really has these agencies under it. And of course, if they spend money or any amount to litigate, then they'll just be spending the money of the government. And so there's PD 242 for these agencies to have the procedure that they need for them to settle. And of course, that there could be adjudication of the disputes between them. In 1978, we had PD number 1508, or the System of Amicably Settling Disputes at the Barangay Level. This one is the first or the initial Katarungan Pambarangay Law. It has a very limited scope. Like I think the threshold for criminal cases is not exceeding 200 pesos fine and imprisonment of not exceeding 30 days. That would be the criminal cases covered under this old law. But for this one, the ADR mechanisms of mediation, conciliation, and arbitration had already been introduced. And there were already procedures that were provided under this law. In 1985, we had EO number 1008, or the Construction Industry Arbitration Law. So EO 1008 created the Construction Industry Arbitration Commission. And it says that under this law, all construction disputes, everything, all transactions relating to construction, and when there are disputes, they should be referred to no less than the Construction Industry Arbitration Commission. Okay, so like procurement contracts, even procurement contracts, if there are, if it involves construction, then it should be referred to the SIA. Okay. So there is no other ADR provider that will accept any construction dispute because there's a law in the Philippines, and only in the Philippines do we have this law, that construction disputes are treated differently, and that it should be decided only and arbitrated only by the Construction Industry Arbitration Commission exclusively. Okay. In 1985, we had the Ancestral Model Law on International Commercial Arbitration. The Ancestral is a subsidiary of the General Assembly, and its goal and its purpose is to make international policies that can be adopted by different countries in formulating their ADR mechanisms. Of course, the ultimate goal is to facilitate trade between these countries. And in fact, we have adopted the Ancestral Model Law in our 2004 ADR Act. So you can see most of the provisions of the Ancestral Model Law in RA number 9285. Okay. Later on, there were amendments. There were amendments to the 1985 Ancestral Model Law, and that happened in 2006, and mostly would refer to interim measures of protection. And of course, since we had our RA 9285 in 2004, we have yet to add this amendments to our ADR code, and that's why it's part of OADR's proposed bill that will be submitted to the Philippine Congress. 1987, we had the Philippine Constitution, and it provided under Article 8, Section 5, Paragraph 5, the simplified and expensive procedure for the speedy disposition of cases. And also, we had EO number 292, or the Administrative Code of the Philippines, which tells us about the functional relations of different government agencies. Okay. In 1991, we had RA number 7160, or the Local Government Code, and this expanded the coverage of PD number 1508. And in this law, for criminal cases, for example, the coverage or the scope was expanded to cases with imprisonment not exceeding 1 year, and fine not exceeding 5,000 pesos. Excuse me. Okay, so, and of course, other procedures that were also emphasized under the Local Government Code for performing ADR mechanisms. And it retained actually the 3 ADR mechanisms under the Katarungan Pambarangay Law, which, as I have mentioned, are mediation, conciliation, and arbitration. In 2004, we had RA 9285 for the ADR Act of 2004. And as you can see, our ADR laws are scattered. And so the move of the OADR to have this codified into one law, and we will be calling it the ADR Code of the Philippines. So we will incorporate what we can incorporate in the ADR code so that there will be only one reference for lawyers and non-lawyers to look at when they are dealing with ADR. In 2009, we had Administrative Matter number 071108 SC, or the Special Rules of Court on ADR. Now, this is the procedural law that we've been waiting for since 1949. And this was issued by the Supreme Court in order to guide the judges, the members of the judiciary, on how they will implement the provisions on the ADR law and how they will treat disputes that are submitted to them when there are ADR clauses or arbitration clauses in these contracts. Okay, so and this is very important because later on you will know that you will not have any use of the regular rules of court when dealing with ADR. Okay, you only look at these special ADR rules when you are dealing with a dispute or a case on ADR. Okay? So we also have DOJ Circular number 98, and that is the IRR, or the Implementing Rules and Regulations of the ADR Act of 2004. So you have to read RA 9285, of course, in relation to, of course, you also have to read the IRR of the ADR Act of 2004 if you want to know more details. Okay. And in 2012, we had EO number 78, series of 2012. This one deals with particular contracts like the public-private partnerships, build, operate, and transfer, and joint venture agreements. These are contracts of private entities with the government agencies. Okay, so like when we build expressways, bridges, so we usually ask for the help of private entities, and so because it is presumed that these private entities are helping the government, then there should be a way of resolving disputes between these involving these contracts, okay, so that they will avoid expenses in litigation and of course inconvenience on the part of both the government and the private party that is concerned. We also have the OJ circular number 49, and I have discussed this a while ago. It talks about the accreditation guidelines and training standards of the OADR, and you have to check this out if you want to become an OADR accredited ADR practitioner. By the way, if you're an ADR OADR accredited practitioner, you can provide services to government agencies. You can be a consultant. You can help agencies to, of course, formulate their ADR mechanisms and their procedures. Okay, so that's where you need accreditation. If you will be providing services to government agencies, but if you're only intending to provide your services to private entities, then you would not need OADR accreditation. But I suggest you avail of OADR accreditation because it will be good for your credentials. And of course, there are certain policy standards that are being followed in the accreditation, and so your stakeholders would always be assured that we have checked the quality of your trainings and, of course, the way you do ADR. Right, and then, of course, I have discussed EO 97 already, which gives the powers and functions on ADR management and coordination from the Office of the President to the OADR. And in 2015, we had the Uniform Rules on Dispute Resolution under PD number 242. So let's look at PD number 242 again, the settlement and adjudication of disputes among government offices. So we have 3 offices involved here in PD 242. The Department of Justice, the Office of the Government Corporate Counsel, and the Office of the Solicitor General. So if the dispute is between national government agencies, then it should be submitted to the OSG. If the dispute is among GOCCs, then the dispute must be submitted to the OGCC. If there are pure questions of law, or if there are if it's a combination of GOCC and or an NGA, then should be submitted to the Department of Justice. And under the uniform rules, they have the same procedures to follow in all these offices, because before, prior to 2015, prior to the to having these uniform rules on dispute resolution, these 3 offices have different procedures on how they will do ADR under PD 242. But by virtue of these uniform rules, they have now the same procedure for each office, and it is settled that the awards given by the OSG and the OGCC are merely recommendatory, and it is the DOJ that has the final say about the award. Okay, so in 2019, the Philippines signed the Singapore Convention on Mediation. And as of now, this has not yet been ratified by our Senate, and the DOJ and the OADR and the DFA is working on the ratification of this. And just to briefly tell you, the Singapore Convention on Mediation is somehow like the New York Convention, but since the New York Convention deals with arbitral awards, the recognition and enforcement of arbitral awards, this time the Singapore Convention on Mediation deals with settlement agreements. And so it has the same effect. Agreements, settlement agreements made in the signatory countries will also be enforceable in other signatory countries to the Singapore Convention on Mediation, again, to facilitate trade and also to encourage investors to invest in these countries that are member countries in the Singapore Convention on Mediation. And that, ladies and gentlemen, is the Philippine ADR law. Let's go to a bar exam question. Okay, that was given last year. So this is the question. In December of 2021, the Tibag Realty Corporation and Kasanga Construction Company submitted their construction dispute to arbitration before the Construction Industry Arbitration Commission. In March 2022, the SIA Arbitral Tribunal rendered an award in favor of Kasanga Construction Company. So what is Matibag Realty Corporation's remedy? Explain briefly. I hope you got the question. Okay, so of course they want to Matibag Realty wants to oppose or somehow explore any remedies against the award because it was made in favor of the other party, which is Kasanga Construction Company. So let us now check the answer. Okay, this is the suggested answer. Matibag Realty Corp, Matibag Realty Corp may file an appeal directly to the Supreme Court under Rule 45 if the issue involves pure questions of law. So you have to qualify the answer. If it involves pure questions of law, it's through Rule 45 before the Supreme Court. But if the appeal involves factual issues, the appeal may be made with the Court of Appeals, but only on limited grounds. And that would pertain to a challenge on the integrity of the SIA Tribunal. That would be if there is corruption, fraud, misconduct, evident partiality, incapacity, or excess of powers within the tribunal. So as you can see, it refers to any faulty issues or matters concerning the tribunal. Okay, all right, letter B. And letter B, allegations that the tribunal violated the Constitution or positive law in the conduct of the arbitral process. The Court of Appeals may conduct a factual review only upon sufficient and demonstrable showing that the integrity of the SIA Tribunal had indeed been compromised or that it committed unconstitutional or illegal acts. And that's the case of Global Medical Center of Laguna Incorporated versus Ross Systems International Incorporated, GR number 230112, 230119, 11 May 2021. I just want to emphasize that the appeal only pertains to any defects in the tribunal's authority to render the award. It does not delve on the merits of the award itself, as you can see and as mentioned in the given grounds for appeal to the Court of Appeals of a SIA award. Okay, this one I mentioned a while ago under Republic Act number 9184 or the Government Procurement Reform Act, where all disputes arising from the implementation of a contract covered by RA 9184 shall be submitted to arbitration. So this is one of those things or disputes that is subject to legislated arbitration, and that is under RA 9184. Now the question is, can the parties only choose arbitration? This provision says no. The parties can actually choose other modes of alternative dispute resolution. Okay? But for the purpose of complying with this provision, it says that the process of arbitration shall be incorporated as a provision in the contract that will be executed pursuant to the provisions of this act. Provided, and this is the part that I'm referring to, by mutual agreement, the parties may agree in writing to resort to alternative modes of dispute resolution. And that would mean other modes other than arbitration. So the parties can do negotiation first, for example, for the first 30 days. And if there's no settlement, they can do mediation for the next 60 days. And if still there's no settlement, then that's the only time they can resort to arbitration. So the parties can freely agree on that terms. Okay. And of course, I've mentioned EO 78 a while ago. Again, just to reiterate, only involves these kinds of contracts. It's not applicable for every contract. Only involves public-private partnerships, build, operate, and transfer, joint venture agreements, And for local government units, under EO 78, they are encouraged to stipulate the use of ADR mechanisms in their contracts, okay, with private entities. Now, EO 78 is a very good source of templates for ADR clauses, because you will find in the annexes thereof various templates for multi-tiered ADR mechanisms, and also when it involves only construction disputes, and also when it involves only arbitration, and also for commercial disputes. So you can find most of this in the annexes of EO 78. If it's your first time to formulate or make an ADR clause for your clients, you can always look at the templates under EO number 78. It's also interesting to read EO 78 because it involves pre-dispute processes and not only post-dispute processes, because the objective is really to exhaust all means to settle the dispute between the parties, because as I have said, this presupposes a dispute by a government agency with a private entity that is supposedly helping the government in, of course, coming up with these projects for our citizens. And of course, we have discussed PD 242. Of course, as I have mentioned, there are 3 offices that are involved here: the OSG, the OGCC, and the Secretary of Justice, of course, under the DOJ. And of course, as I've mentioned, the awards given by the OSG and the OGCC are recommendatory and for final approval by the Secretary of Justice. Right, so, okay, so for 1 million and below, okay, it is not subject to appeal anymore. If the award is 1 million and below, the amount involved is 1 million and below, it's not subject to appeal anymore. But if the amount in the award exceeds 1 million, it is appealable to the Office of the President. So let's not forget that. If it is 1 million and 1 peso, it is already appealable to the Office of the President. Right, so of course, the uniform rules, you have to check the uniform rules if you're going to submit any dispute to any of these offices, the 3 offices. You have to check the procedure under the uniform rules on dispute resolution, and this is common for all these offices. And the recent jurisprudence that mentioned PD 242 is the one penned by Justice Singh. It's DOE versus CTA, GR number 260912, August 17, 2022. So there's this dispute between DOE and the Court of Tax Appeals, and it reached the Supreme Court, and the ruling was for them to refer the dispute to ADR under PD 242. So yes, so PD 242 itself highlights the practical considerations for administrative settlement to avoid litigation, wherein the government is ultimately the only party in interest, and to avoid needlessly contributing to clogged court dockets and wasting government resources. And so this dispute was declared by the Supreme Court as covered by PD 242, and the parties should refer the dispute to these offices under PD 242. And you will see here the procedure under the uniform rules. Of course, commence arbitration, there's a constitution of the tribunal, and there will be proceedings post-constitution of the tribunal, and there's mandatory conciliation embedded in this arbitral proceeding. Of course, so within 15 days from receipt of the answer, or after the lapse of 30 days from the issuance of the order to file answer, there will be mandatory conciliation. And then there will be preliminary conference within 3 months from the date of conciliation conference, without the possibility of an amicable settlement. And they will have to submit evidence. There will be conduct of hearings. There will be an arbitration resolution, or the draft will be prepared within 30 days from the submission of the parties' memoranda, and there will be post-arbitration proceedings. I just want to emphasize that there's a difference, because you might be confused why there is ADR under the executive and there's ADR in the judiciary. ADR in the executive is managed and promoted by the OADR, and that's for out-of-court settlements, while the ADR in the judiciary is governed by the Supreme Court of the Philippines. So, of course, we provide trainings to give this education trainings and campaigns for our stakeholders so that they will know that there are ways to settle disputes out of court, and that it's not only court annex mediation that we have, and that there are different bodies and tribunals that can assist them in settling their disputes. One of that under DOJ is the DOJ Action Center. If parties would want free ADR, ADR services, the DOJ Action Center can give that to the parties. And of course, there's also ADR mechanisms embedded in the procedures of the Public Attorney's Office and other agencies of the government. And of course, we accredit our own practitioners. For the judiciary, they have their own accreditation system, and they have their own accredited court annex mediators, and they do their mediation in the Philippine Mediation Center. And of course, they have their trainings under the PhilJA also provides these trainings for them. And right now, the OADR is coordinating with the Supreme Court regarding these trainings for us to have coordinated programs. And so for us to have a holistic approach in ADR. All right, let's go now to the forms of ADR. Of course, we have negotiation, conciliation, mediation, mini trial, early neutral evaluation, expert determination, dispute boards, and of course, after the broken line, we have arbitration and litigation. Those on the left side of the broken line, there's maximum party control over the outcome of the disputes. And of course, there's focus on consensus of the parties. It's confidential, it's informal, and there's minimal external intrusion. Okay, there are third-party neutrals here, save for negotiation, but the third-party neutrals here do not actually render any decision or award on the merits as compared to arbitration, okay, or in litigation. Okay, so that's why they are on the right side of this spectrum. For those on the right side, where we have arbitration and litigation, there's third-party control over the outcome. As I have mentioned, in arbitration, the arbitral tribunal renders an award, and it is a determination of the legal rights of the parties based on the merits and the presentation of evidence of the parties. And well, for arbitration, the proceedings are confidential. But for litigation, of course, we know that it's public in nature and anyone can just enter the courtroom and observe the proceedings in the court. And there are more formal rules or processes in arbitration and litigation. And by the way, if you study arbitration, please don't get overwhelmed, because you're going to study a lot of new laws that you have not encountered in law school. And of course, you have to study the rules and procedures of each, of course, of each tribunal or each institution where you will lodge your dispute, because there are different rules for each institution. For example, the PDRCI or the PICCR, they have different sets of rules. For example, you go to the ICC. Okay, so there's maximum external intrusion because there's an award given, for example, in arbitration, and for litigation, there's a decision made by our courts. Okay, so So you can see here, these are the enumerated forms of ADR mechanisms under RA 9285, but I have to tell you that these are not exclusive. And the parties can always combine this, make a hybrid version of this, or determine another mode which they think is best suited for their dispute. Let's go now to negotiation. Here, there's no third party neutral that is involved. It's the parties talking with each other. But you should know that there's a lot of skills and trainings required for a lawyer or a non-lawyer to become a good negotiator, because this is difficult to do because there's no third-party neutral here. It all depends on how the parties themselves would handle the negotiation, and it requires a lot of skills in order to really effectively negotiate with another party. And so the OADR offers 24-hour training course on negotiation that is patterned after the program on negotiation of the Harvard Law School. And of course, we have mediation. It's a voluntary process that is being facilitated by a third-party neutral. And here, since it's just facilitative, so the third-party neutral does not have any authority or right to make any suggestions, nasty comments, or any. Of course, the mediator cannot generate options for the parties. It's only the parties who can generate options for possible solutions to their dispute. And then we have conciliation. In conciliation, there's more active participation of the third-party neutral, in that here the conciliator can actually suggest or identify a solution which the parties can actually choose from, or you can help the parties to generate options. Okay? In arbitration, the parties may only submit a dispute to arbitration if it's agreed upon by them in the arbitration clause in their contract, or if there is none, through a submission agreement that was executed by the parties after the dispute arose already. And so the authority of the tribunal comes from the agreement of the parties to have it subjected to arbitration. Otherwise, they should go to the regular course of dispute resolution, which is the courts. Okay, so here there's a tribunal that actually hears the parties, and of course there's presentation of evidence if the parties choose to do so, and there will be an award. The output would be an award rendered by the tribunal based on the merits of the dispute. And of course, all throughout these proceedings, fairness and equal opportunity is given to the parties in presenting their positions in the dispute. Early neutral evaluation is done by an expert, and the output would be a non-binding assessment by an experienced neutral person. Of course, it's non-binding, but the parties can actually use this as reference in order to decide whether they would settle or not. At least coming from an expert, then maybe they would have certain considerations on the assessment given by this expert. This is actually done by judges in JDR because these judges are experts, so they can actually give non-binding assessments. That's why you cannot have your JDR in the same judge and have the case heard by the same judge. So that's why, because there is early neutral evaluation that is being done also in JDR. And there's mini trial, and in mini trial, you have here the senior decision makers of each of the companies. For example, companies A and B. Okay, so the representative of company A will have to present the position of company A to the senior decision makers of company B, and vice versa. And the senior decision makers of both companies would then decide if they will negotiate. They can also seek mediation and engage the services of a third-party neutral to to have their dispute mediated, and they can also proceed to arbitration if they want to. There's the two-tiered ADR mechanism, that's med-arb. And a while ago, I have mentioned about multi-tiered negotiation, mediation, and arbitration. And of course, there's nothing that will prevent the parties from exploring these steps towards the settlement of their dispute. Okay, I think this is my final slide. And of course, this is just a comparative table of all the ADR mechanisms that are available to the parties, and of course their benefits and the downside of securing this ADR modes. Well, the only question that we always encounter is about arbitration when we say it's cheaper, because their lawyers and non-lawyers would argue that it's not cheap to go to arbitration. But as I have said, since in arbitration, the dispute is resolved in a speedy process, and so the parties significantly would save a lot of expenses as compared to litigation, which would take how many years and sometimes even decades if it will reach the Supreme Court. And so, yes, arbitration is still cheaper than litigation. And of course, the time that's involved here, and mostly it's the consideration of the parties, because as they say, justice delayed is justice denied. So if you will get the award in a year's time, for example, then I think that would be satisfactory for the parties, instead of getting a decision later on after 7 or 10 years. Okay, so of course, in all these ADR proceedings, confidentiality is observed. And of course, fairness is observed. And if there's a question on the fairness of the tribunal or any defect in the tribunal, then as I have mentioned, like for SIAC awards, you can always go to the Court of Appeals to question the award based on the defects in the constitution of the tribunal, or any corruption, or any problem with regard to the tribunal. And that's it for today. So I will stop sharing now. And of course, I'd like to thank all of you for watching and for staying until the end of my presentation. Please visit the VLC website at www.villasislawcenter.com and to know more about the Virtual Law Companion. Prepare for the bar examinations at any time, anywhere, and from any mobile device. Together, we can. Thank you.
Walang natira video. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period. Pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
walang natira video period. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang ang epekto, maximum period. Offset rule, i-offset mo muna, tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, section.
You have to be guided by Section 1 of Rule 138 because Rule 138 is one of the sources of legal ethics. Who may practice law? Ang sinasabi dyan ay any person heretofore duly admitted as a member of the bar or hereafter admitted as such in accordance with the provisions of this rule and who is in good and regular standing is entitled to practice law. Iyan po iyon. That is ULEP versus Legal Aid Clinic. ULEP versus Legal Aid Clinic. Okay? Yan yung doktrina. Alin yun, sir? Yung any person. Kasi any person may mean na pwede palang mag-practice. Kung hindi yan natin makokorek, pwede palang mag-practice ang juridical person. So let us disabuse.
The shares of XYZ, the 40% shares of XYZ, likewise owned by the same foreign corporation owned by foreigners that directly owns 40% of ABC Corporation. So to repeat, let's say the foreigners, right? The foreign held corporation owns 40,000 of 100,000. At the same time, the foreign held corporation owns 40% of XYZ share in ABC Corporation. So the question now is, based on these figures, is ABC a Philippine national? Is it qualified to invest in public utility? Is it compliant with the Constitution?
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply, under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk...
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together, we can.
Walang natira video. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna, tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1,